maybe I can put in brackets independence of a state or a country. Independence of a state or a country. So basically, it means that once a particular body or a particular jurisdiction has come up with their own laws, they become sovereign, or actually they become independent. So this basically means that, for example, if you look at the laws governing a country like Uganda and those ones governing a country like Kenya, they're actually very different. So those laws actually make Uganda become a unique country. Those laws actually make Kenya become a unique country. If you go to Tanzania, they have their own laws. Those laws actually make them to become sovereign, or actually basically an independent state. So maybe if you look at maybe the structure of government of this one is actually very different from the structure of government of this one as outlined in their constitution. So each and every constitution of a country will actually basically make that particular country become sovereign or basically independent from another country. So for example, you can put it in simplest way. For example, if we have in our normal setups, like for example, if you find that maybe different, if you have like a chama that has its own bylaws. So these bylaws actually make that particular chama to be sovereign or actually dependent from any other chama. So laws actually basically make, or they actually relate to the concept of sovereignty or actually independence of a state. So the laws will actually make a country become an independent country. So it will have its own laws that actually guide people in that particular country. So no one else can actually be able to come and actually be able to dictate on how basically those persons in that particular country can actually be able to relate to each other. So they make a country to become independent from any other country or any other state as a result of the laws that have actually been put in place in their constitution. Then another characteristic that you can actually be able to talk about is it is backed. Let's say it is backed. It is backed by coercive authority. It is backed by coercive authority. And then you can actually be able to say its violation leads to punishment. Its violation leads to punishment. The violation of the laws will actually basically lead to punishment. So if you violate the laws in place, then of course there's actually a punishment, or maybe you can say there's actually a penalty, or you can actually be jailed. So there's usually a punishment if you basically violate any law that has actually been put in place. For example, if you have a school that has its own laws, or basically rules and regulations, then you violate the rules and regulations, then of course you'll actually be punished by the teachers. If it is actually the country, you basically violate the laws that are actually in place. For example, being involved in any illegal activity that is outlawed by the constitution, then basically you can actually be punished either by being jailed, or maybe by being penalized, or being asked to pay a fine. It is backed by a coercive authority in that most of the time you find that there's usually coercion from the government. So the government tries to enforce it. If you go against it, for example, if they have actually prohibited, for example, maybe demonstration violently, then you demonstrate violently, then of course they can actually be able to bring in the police. So the police can actually be able to come in to basically ensure that people are actually following the law. So there's usually coercive authority. Basically, people are actually forced so that they can actually be able sometimes to follow the laws and regulations in place. So the country or the state has to basically implement the laws, basically ensure the laws are actually being followed through what is known as coercive authority. Basically ensuring they are the police, we have administrators in place to be able to ensure laws are actually being being followed. So it is actually backed by coercive authority. So it has to be backed by coercive authority or someone in place who can actually be able to ensure people are actually following the laws, Then another one we can actually be able to talk about, it regulates. It came out in the definition, it regulates human conduct. It will actually basically regulate human conduct. How people actually behave will actually depend on the laws in place. So those laws will actually basically guide on how you're supposed to conduct yourself as an individual. If it is in a school, those laws will actually guide you on how you're supposed to conduct yourself. Maybe when the bell rings, you're supposed to run. So they basically regulate how you conduct yourself as a human. So human behavior will actually be guided by the laws that are actually in place, in place. Then another one, which is very important, it is dynamic. It is dynamic. It is dynamic and it keeps changing and keeps changing depending on the society, So law is not static. So it will actually keep on changing with maybe the needs of the people, with maybe how the society, or depending on the society, it will actually keep on changing. So, like for example, right now you can see they are saying they are going to change the Kenyan constitution. So they're going to change the laws that are actually basically guiding us as Kenyan people. So as society keeps on changing, so their needs actually keep on actually also changing. So laws will actually basically keep on changing depending on the circumstances in place, or maybe circumstances actually surrounding those people in a particular society. So it is actually very dynamic. So law will actually be very dynamic. It will actually keep on changing with time. So you find that the laws that are actually being applied, for example, 40 years ago, maybe 20 years ago, 10 years ago, are not actually the same. So due to maybe certain needs or maybe circumstances in the society, then of course laws can actually be changed. So laws are actually very dynamic and they actually keep on changing. So they keep on actually changing with the society or depending on the society or the needs of the society. So these are some of the key characteristics. If you look at maybe the definition of law, or if you look at law in generally, you understand it generally, then you'll basically realize these particular characteristics will actually be able to come up. Will actually be able to come up. So we are saying it is a set of rules. They are basically just rules that have actually been put that one must actually be able to follow. Then it is created and maintained mostly by the state. It is dynamic. It keeps on changing. It is actually backed by coercive authority. It must actually be enforced. There must be people in place who are actually enforcing the laws. For example, if it is in a school, the teachers are actually in place, the school prefects or the school captains are actually in place to be able to ensure they're actually enforcing the laws that are actually in place. If it is in our country, we have the police, we have the courts. So the courts are actually in place to ensure that the laws are actually being followed. Then it regulates human conduct. It will likely guide on how people will likely be able to behave in a particular society. Will likely be able to behave in a particular society. So we can look at some of the purposes. So the main purposes of law. So you can look at purposes. What are the purposes of law? Purposes of law. You can look at purposes of law. So, to regulate the behaviors of individuals in a society, to regulate the behaviors of individuals, to regulate the behaviors of individuals in a society, in a society, in a society, in a society. We can actually be able to talk about to ensure political, social, and economic stability, to ensure political, social, and economic stability, economic stability. So we talk about political, maybe with regard to maybe the structure of the government or how politics are supposed to be carried out in a country. Social things to do with maybe requirements with regard to maybe health or maybe education. Economic, how can people actually be empowered? So laws will actually can actually be set up to ensure there's actually economic stability by being able to maybe ensure they come up with laws like devolution laws that will actually be able to empower people. Finance laws, or we can talk about the Finance Act. So this is basically distribution of resources to the people. So laws can actually be able to ensure there's actually economic stability in a country. So they come up with laws that are actually basically ensuring the country is actually basically progressing in terms of the economy by being able to maybe share the resources or share the revenue that is raised by Kenya Revenue Authority appropriately in the budget, because the budget will actually basically be approved by the parliament. So there must be a law in place that is basically appropriating or basically distributing the funds to different sectors in the economy. So laws must actually be in place to ensure there's actually economic stability by basically sharing resources appropriately. So things to do with politics, for example, changing the structure of the government, ensuring that there is actually efficiency on how things are actually carried out by the government. Things to do with maybe election laws. So election laws that are actually in place should actually ensure that they're actually good laws to ensure that there is no actually political chaos. So laws can actually be able to ensure there is actually political, social, and economic stability in a country. Then we can actually be able to talk about to ensure there is peace and security, 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 to ensure there is peace and security in any jurisdiction, to ensure there is peace and security in any jurisdiction, to provide justice to individuals, to provide justice to individuals, to provide justice to individuals. For example, if there's anyone who has actually basically violated any law against you, then of course you can actually be able to take him to the courts. For example, it is actually against the law for someone to steal for you or steal for you. So in such a case, you can actually be able to take him to court and you'll actually be able to get justice, because there are actually laws in place that are basically prohibiting anyone from actually stealing your property. So you can actually basically provide justice to individuals. So it provides justice to individuals, provides justice to individuals, provides justice to individuals. So those are some of the main purposes. So some of the main purposes of law. So we can talk about maybe the last one. We can talk about provide fundamental rights, to provide fundamental rights and freedom of individuals, to provide fundamental rights and freedom individuals. So we can talk about, for example, right maybe to own property in a country, right to live anywhere in the country. So those are some of the fundamental rights that you can actually be able to enjoy as a citizen because they are actually enshrined in the Constitution. So you have a right to live anywhere in Kenya because that law is actually already in place. It's protecting your fundamental rights as a Kenyan citizen. You have maybe freedom to be able to demonstrate and actually take a history. So those are basically laws that have actually been pushed to protect your fundamental rights and freedoms as an individual. So as a result of the laws, then of course you have those rights. You have those rights. So those are some of the main purposes of law. The main purposes of law, or the main purposes of law. The main purposes of law. So generally, law is actually applied in many ways in business. So as we learn more, we basically discover law is actually very important in business. For example, I'm giving an example like maybe things to do with contracts. So in this case, we'll actually be able to learn about things like insurance contracts. Insurance is a business. Insurance contracts, we learn things to do with, for example, like sale of goods contract. Those are things that like maybe hire purchase contract. So these particular contracts, there are laws in place that basically regulate this kind of contracts. For example, you want to incorporate a business, there are laws in place that you must actually be able to follow before you register your business. So you can't just register your business. So there are certain requirements that you must actually be able to fulfill under the law before your business can actually be registered. Either you are registering as maybe a sole proprietor, either as maybe a company. So law is actually applied in many ways in business. That's why it's actually very important to be able to learn more about business law. So it is very important to ensure there's actually efficiency in business. So I'll give you an example. For example, if someone basically violates a contract, for example, under hire purchase, because there's already law in place, then of course you can actually be able to seek justice in a court of law. So law is actually very important in business, just to ensure there's actually efficiency of transactions that are actually being carried out in business. Without law, then of course we can't have efficient business. We can't have efficient business. For example, if it is maybe under sale of goods, you as a buyer, you have certain rights under the sale of goods agreement or actually a contract. If the seller violates those particular rights, then of course you can actually be able to go to court because there are already laws in place that actually basically regulate sale of goods contracts. So law in business basically ensures there's actually efficiency in carrying out business transactions, So we can look at classification of. We can now look at classification of law. Classification of law. So now the first one. Written and unwritten law. Written and unwritten law. So written, that's from the word written. It is written. It is actually contained somewhere in a document. It is actually contained somewhere in a document. Then unwritten is not actually basically written anywhere, but it can actually be applied as a law. It can actually be applied as a law. So written law basically means already I've told you what is actually law. their rules and regulations. So these rules and regulations are actually being contained in our documents. So it is actually written law. So basically, these are basically rules and regulations that have actually been contained in a document. So the most dominant one that I can actually be able to give as an example is the Kenyan Constitution. So it is actually written somewhere. So those laws are actually basically contained in what is known as a document known as the Constitution. So you can have, for example, acts of parliament. So those are basically actually contained. You can actually be able to get them if you look at the Kenyan. So when you talk about written law, then this basically refers to the law that has formally been enacted and is actually contained in a formal written document. So written law is contained. Written law is contained in a formal written document. Written law is contained in a formal written document. E.g., I can give you an example. E.g., the Kenyan Constitution. The Kenyan Constitution. So I'm actually be able to get it from the government printer. So it contains somewhere in a document. It is written down. You can get it and actually be able to read it. You can actually be able to read it. That's from the word written. So since they actually contain somewhere, then they can actually be classified as written law. So it's contained in a formal written documents. So there are laws or regulations that have been contained in a formal written document. So that give the Kenyan Constitution or Act of Parliament. Act of Parliament. Act of Parliament. An Act of Parliament is basically a law that is actually made through Parliament. It's actually a law that is actually made through Parliament. So that's why we say members of Parliament, their main role is actually to make laws in Parliament. So they're actually appointed by the people to go to Parliament and actually make laws. So the laws they make, they're actually known as laws they make, they are known as acts of Parliament. So acts of Parliament. So these ones can actually basically be gotten. Those laws they make in Parliament can actually be gotten in a written document, or formally written document after it has actually been enacted by the Parliament. Then when you talk about unwritten, so this is not contained, it is a law that is not enacted by Parliament, it is not contained in any written formal documents. So it is not contained in any formal written document, or you can actually simply say unwritten law is law which has not been enacted by Parliament. Unwritten law is law which has not been enacted by Parliament, and is not contained in any formal, and is not contained in any formal document. It is not contained in any formal documents. So you can't actually be able to get any document that basically is outlining this kind of laws. An example you can actually be able to give is what is known as the common law of equity, maybe the African customary law. So our customs, you can't actually be able to find our customs having been written anywhere. So these are things that we have actually been practicing for a very long period of time. But since that is basically applied as laws in the society. Basically, for example, how we pay our dowry. So there are laws that are basically followed, and basically paying dowry somewhere in a particular community. So these laws are not actually written anywhere, but of course they are actually applied. So you basically have to follow them. Basically, you're going to pay the dowry, then you have to follow those particular laws. You must actually bring maybe goats. If you go to another society, you are supposed to take maybe cows. If you go to another society, you're supposed to maybe give money. So that is their mode of actually basically paying There are laws that were actually set by our ancestors, and they actually still existing up to now. So they are not written anywhere, but of course they are actually applied as well. So you can't actually be able to go against them because those are actually basically what are known as African customary laws. So the African customary laws that must actually be followed. So you can give an example, e.g., the African customary laws. We learn more about African customary laws when we look at the next topic, which is actually sources of law. So African customary laws, African customary laws. So you can't find anywhere where our customs have actually been formally written. But you still follow those particular customs. So those customs still actually basically guide us as a people in a particular society. So you go to a particular community, they have their own customs, if they basically follow us as laws. So you can't go against them. So they are already laws in place, although they are not formally written anywhere. We have like you can give like a common law. Common law. We learn more about common law. So this is the traditional English law. This was actually practiced in the ancient times in England or the United Kingdom So let me change that battery. So saying examples of unwritten law, we can have the African customary law, or maybe the common law, which is the traditional English law. So it was actually basically practiced. So here in Africa, we have African customary laws. In England, we have what is known as the common law. So that is the traditional law that they are actually basically practicing. So this law was actually basically derived from the traditions of the English people. So it is known as the common law. It is not formally written anymore, but of course it was actually basically applied as a source of law for this particular people, the English people. So we learn more about common law in our next topic. So the next classification that you can actually be able to look at so we can have what is known as private. So now number 2, private and public. So you can have what is known as law being as private law, or maybe being public law. So when you talk about private law, it is a segment of law that governs the relationship and disputes between private citizens of a country. So private laws, you can say private laws are laws that govern disputes between individuals or a state or a country Just from the word private, so it governs individuals. So for example, if you have a dispute between maybe Abby and Lucy. I can see Abby and Lucy here. So that particular dispute will basically be resolved under what is known as private law. Private law. So it basically governs the relationship, or basically tries to govern dispute. So you can say govern relationships. You can say govern relationships. Govern relationships and govern relationships and disputes between individuals of a state or a country, between individuals of a state or a country. So the difference with basically public law basically governs the relationship between individuals and the states. You can see private law. Private law, we are saying it is between individuals. But on the other hand, we are saying public law, they likely be between an individual and the state. So maybe you can say maybe the government, so that you understand the state or the government. So any dispute between an individual and the government will basically be resolved, or that law that will basically govern the relationship between an individual and the state will actually basically be termed as being public law. So you can say basically there are those laws that try to basically protect the interest of the citizens of a country or individuals in a country against the state. So you have any law that is basically guiding on how the state should actually govern the country. That law will actually be termed as actually being public law. If the state actually violates that public law, then of course this particular individual can actually be able to take any action against the state. For example, you as a citizen, you have a right to be able to get certain basic services from the state. For example, maybe health. So if you don't get those particular basic services, the law that will basically be applied to resolve such a relationship or a dispute will actually be termed as actually being public law. But of course, for private law, we are saying it is just basically govern the relationship between individuals in a state, not between an individual or a citizen of a country and the state. The examples you can actually be able to give of private law is, for example, you can talk about, for example, there are many of them. So law, we can have law of tort. So a tort is basically committing a wrong against another person. So that law that will basically govern that relationship will actually be termed as the law of tort. So law of tort is actually an example of a private law. So public law, it governs relationships between individuals and the state. So it tries to protect the interest of individuals in a country against the state. So if the state goes against any laws, then you can actually be able to take any action as an individual against the state. Or for example, you as an individual, you have committed a wrong, then of course the state can actually be able to use what is known as public law against you as an individual. So maybe you can just write something brief about public law. Something brief about public law. So you can say this one. I'll just say private law. Private law, it is also known as civil law. 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 Give examples, e.g., examples of classifications under, you can have family law, e.g., family law, law of tort, you can have law of tort, you can have law of tort, law of property, law of property, law of property, you can have law property, you can have law of property. Then we are saying public law. So we are saying public law. Public law governs the relationship. Public law governs the relationship between individuals or citizens, individuals or citizens, and the states, and the states, and the states. When I mention the states, just remember the government. So that relation between the individual or citizen, a country, and the government. The law that is basically protecting the interest of those particular two parties, and I think we categorize as being public. It is for everyone in the country. It is for everyone in the country. So it will be termed as actually being public law. You can actually give examples, e.g., constitutional law, the constitution, it protects your interest, you as a citizen, against the state. So the country or basically the government can't actually be able to do anything without following the requirements that are basically outlined in the constitution. For example, if the constitution basically states that the government must actually appoint maybe 10 ministers, maybe 10 cabinet secretaries, there's nothing the government can actually be able to do, because if they maybe appoint more, they might be violating the requirements under the constitution. For example, right now, the government basically is trying to push for the change of the constitution so that they can actually basically include the post of the prime minister. So they can't just wake up any day and say that they are basically going to appoint a prime minister, because that one is not contained in the constitution. Because if they do so, then any citizen, because you know some of them, like maybe Okia or Tata, can actually be able to go to the court and basically dispute the appointment of a prime minister without following the constitution. So the government does so, will have actually basically violated the requirements under the constitution. So this basically tries to protect an individual against the state. So those rights, that relation between an individual and the state, will actually be governed by what is known as public law. So this one basically ensures there's actually maybe peace and maybe stability in the country, peace and stability in the country, and tries to regulate and maintain the peace between citizens and state or the government, the state or the government. So you can have a constitutional law, or maybe let me give you another one: administrative law, among others, etc. Even here we have etc. We have many of them. So we have etc. Then another classification that you can actually be able to have is what is known as criminal and civil law. 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 I just say criminal law is a law that defines a crime. That defines a crime or a wrong. It's a law that actually defines a crime or a wrong. 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 So I think I just say a crime. A crime is a wrong against the state. Is a wrong against the state. Is a wrong against the state. So criminal basically try to define a crime or a wrong. We're saying a crime is basically taken as being a wrong against the state. So you can say the proceedings in a court of law will be commenced by the state. The proceedings in a court of law, will be commenced by the state. Will be commenced by the state. Will actually be commenced by the state. Will actually be commenced by the state. So there are certain wrongs when you actually commit them, it will actually be taken as actually being a wrong against the state. So the state will actually basically take over that particular matter and will actually basically be the proceedings in a court of law will actually be taken over by the state. For example, you can give the most dominant one is, for example, if someone commits murder, in such a case, the state will actually take over the matter. So that is a criminal case. So a criminal case, you can talk about maybe robbery with violence. Maybe someone committing murder. In such a case, that particular wrong will actually be taken as being a wrong against the state. So if someone commits murder by killing someone else, what you normally see, the government will likely basically take over the matter. So that will likely be taken as actually being a wrong against the state. So this particular criminal law will actually basically try to define what can actually be taken as a wrong against the state. I've given the most dominant example is, for example, committing of murder. Someone commits murder, that's wrong, that crime is a wrong against the state. That's why we have basically state prosecutors basically taking over the matter, Sometimes you've seen, for example, if someone is involved in corruption, you just heard that some people have actually been involved in actually stealing money from Kenya Medical Supplies Agency. So the money that was actually basically supposed to buy maybe protective gears or maybe masks for people to be able to wear. So now the government is basically saying that they are going to carry out investigations. So that particular wrong of stealing money that is actually meant to buy those particular gears will actually be taken as actually being a wrong against the state. So that is actually being taken as a crime, being involved in corruption. So the proceedings will actually be in a court of law will actually be commenced by the state or the government. So you have the president saying the investigative agencies. So that is the Director of Criminal Investigations. So the Kenya Anti-Corruption Commission will actually be able to take over the matter and basically carry out investigations. If there are any evidence, then that one will actually be taken as being a crime or a wrong against the state. So in that case, the state will actually take over the matter. In most instances, you've seen in scenarios whereby someone has actually been found to have murdered someone else. And of course, the state will actually take over the matter. The police come and arrest the person, and state prosecutors actually take over the matter. So this one, I think you've seen it in several places. For example, there is one case that is actually ongoing. So there's someone who has actually basically been involved in two cases: corruption and also murder. I think right now, so if you know him, so his name is this one. He's actually right now being investigated for having been involved in corruption, for stealing money in a particular county. And of course, this one I hope you can actually be able to remember. There was a certain lady that was actually involved. It was claimed that this guy actually murdered the lady. So that was actually basically a wrong against the state. That's why the government took over the matter and he was actually taken to a court of law. Right now, he's actually facing corruption together with the family. So that is an example you can actually be able to give. The law that will basically be applied will actually be criminal law. So basically the law that is actually basically trying to define what is a wrong against the government. For example, it defines things like maybe corruption. Which kind of corruption is actually basically a wrong against the state. So that law that is actually basically in place, that will basically implicate such persons will actually be termed as actually being criminal law. So that is criminal law. So this particular person is just a suspect. He will actually be taken as being a suspect until actually proven guilty. So they have to carry out investigation and find out whether it is actually really true what is supposed to be maybe jailed or maybe penalized for the wrongs he has actually committed with regard to maybe corruption or maybe murder. So he still remain a suspect until when actually proven guilty. Then when you talk about civil law, I think I've already defined it. Just the same as private law. That's the same as private law. So you've written this one. You've written this one. So we can talk about civil law. So civil law is a branch of law that defines civil wrongs. So we have tried just to define a bit different. Civil law is law that defines civil wrongs. Civil wrongs. Civil wrongs defines civil wrongs. Defines civil wrongs. And remedies available. And remedies available for the same. And remedies available for the same. So what are the remedies? Actually, in place, if someone is actually involved in what is known as a civil wrong, exactly what is known as a civil wrong. So civil actions can actually be commenced by a person. So the civil actions in a court of law. So we can say civil actions in a court of law will be commenced in a court of law. Will be commenced. Will actually be commenced by a person who seeks compensation for loss. By a person who seeks compensation for loss. Who seeks compensation for loss. So this most definitely actually applies to individuals mostly. So this basically mostly applies to individuals. You've seen under criminal law, you are actually basically committed a wrong against the state. Under civil law, mostly it basically does apply to individuals. So if, for example, you wrong someone with regard to maybe under law of contract, you've not actually basically met your obligations under contract. That other person can actually be able to apply what is known as a branch of civil law under what is known as a contract law. It depends on which kind of contract. Is it hire purchase? If, for example, you entered into an agreement under hire purchase or buying goods under hire purchase, then of course you as a buyer you've not actually been able to pay for the goods on the right time. Then of course the owner of the goods who's selling the goods, you can actually be able to basically go to court and actually basically bring what is known as a civil action. So you can see this case is basically just a dispute between individuals, the buyer of the goods under hire purchase and the owner of the goods. So that's wrong you've actually committed of you not actually being able to pay for the goods when the installments actually fall due is what can actually be termed as actually being a civil wrong. So that is just a civil wrong. So basically civil law is trying to define what actually is civil wrongs. So there are different branches of law that are basically involved under civil law. For example, you can have contract law. That's the one like I'm using, like hire purchase contract. You can have, for example, law of property, law of marriage, law of succession. If, for example, under law of succession, we have a dispute with regard to maybe inheritance of property in our family, then that is just a dispute between the family members. So there are wrongs that have actually maybe been committed by one member of the family to another member of the family. Maybe they're actually brothers, so they can't actually be able to agree on how they're supposed to basically divide the property that was actually left behind by maybe their father or maybe mother. So such a case, maybe there's one who wants a bigger share than so he's actually committing a wrong against the other brother. So they can actually be able to take what is known as a civil action in a court of law. The law that will basically guide on how the judge will actually come up with the remedies or solutions or compensation for the one who has actually incurred a loss in such a scenario will actually be termed as actually being civil law. So under civil law, we have other branches like what I'm talking about, contract law, law of succession. So those ones are basically laws that basically try to resolve disputes between individuals. So those wrongs that are actually committed in those particular kind of laws or actually contracts will actually be termed as being civil wrongs. So wrongs against another individual. Under criminal law, see, it is basically a wrong actually having been committed against the state. So certain wrongs, if you actually commit them, they'll be taken as actually having been committed against the state. We'll give an examples, for example, corruption, maybe actually being a person being involved in, but those are wrongs against the state. But of course, other wrongs can actually basically be defined under laws like maybe law, contracts, not meeting the obligation under a contract. For example, in this case, if I fail to teach you as your teacher, then of course I've actually committed a civil wrong. You can actually be able to take action against me as because you've actually been able to pay for the services. So that is a civil wrong. You can actually basically go to court and the court will actually give what is known as compensation. So we basically claim for your fees, but you can actually claim for your fees, but if you don't get the service, the service. So that is what we mean by civil law. So you can give examples, e.g., you can just say e.g. Contract law. You can give an example like contract law, succession law. You can give an example like succession law. You can give an example like property law. So these are among the branches that can actually be able to come under civil law. Can actually be able to come under civil law. So you can maybe look at the last one. So you can have procedural and substantive law. Procedural and substantive law. Procedural and substantive law. So I can see Muito was asking here. Kindly define the penal code. So kindly define the penal code. I think you've been answered by both lady. So both ladies say the system of laws connected with the crime or punishment. So penal code is basically a law in place, basically trying to define what are actually crimes. What are some of the wrongs if you actually commit will actually be taken as actually being crime. So we can have each and every state or actually country having their own penal code. So if you commit those wrongs that are under the penal code, then it will actually be taken as actually being a crime against the state, So I think you can actually wind up with this one. You can wind up with this one, then we'll likely meet in the next class where we start our next topic. But of course, I'll likely be able to provide a detailed note. So when you talk about procedural laws, so these are laws that have been laid down to detail rules for the guidance of the courts and regulates the manner in which the proceedings are to be conducted in civil and criminal cases. So these are basically just procedures that are actually already in place to guide on how courts are supposed to carry out, basically determine cases with regard to maybe criminal or at least civil cases. So what are the procedures that are actually in place? So those procedures, then of course, will be taken as actually rules and regulations guiding on how courts are supposed to make determination under any criminal or maybe civil cases. So when you talk about substantive law, so consists of actual rules of law. So substantive means there's already a law in place that is guiding on how the court will make a determination. So what the court just needs to do is just to make a reference to that law. So that law is actually already in place. So that is what we mean by substantive law. So substantive law consists of actual rules of law on which judgment of the court is based. For example, if it is maybe a dispute, what can we actually talk about? Maybe to do with the insurance. Then what the court just needs to do is basically to look at the law that is regulating on how insurance is supposed to be carried out in the country. For example, the Insurance Act. The Insurance Act has already the procedures on how maybe disputes can actually be solved under insurance. For example, we have the insurer and the insurance company. If they have any dispute, the court can actually be able to refer to the law already in place. So we have already substantive laws that are actually already in place. But in the absence of substantive laws actually in place, then of course the court can actually follow certain procedures. So those procedures that have actually been set out, those rules that are actually guiding those procedures, can actually be termed as actually being procedural laws. So the court has no any other reference to be able to make a determination. But if they have another reference, that other reference will actually be termed as actually being a substantive law. So it gives conclusiveness on how basically a particular matter can actually be resolved in a court of law. So the court just needs to make a reference to that law. So that law will actually be termed as being substantive law. So there is a law already in place that is guiding on how, or there are basically rules and regulations already in place that are guiding on how courts will actually make determinations or actually judgments, determinations of judgments. So I think we can end there. So unless we have a question, you can ask. But I think we'll meet next time. We'll meet next time. So today was just an introduction. But I think from next time we'll likely be able to cover more. We'll likely be able to cover more. So boss lady says notes on this. I think I'll actually be able to provide later. So you're asking for notes on this, so I'll be able to provide on this one. I'll send you the notes for the first topic. I'll find a way on how I'll actually be able to send you the notes. So you don't have to worry, I'll actually be able to send you the notes. I'll send you the notes. Or what you do alternatively, just inbox me on WhatsApp. So you have my number from the WhatsApp, but you can inbox me. I'll actually be able to send you the notes for this particular first topic. So those ones I send are actually very good. So what these ones are just put here are actually in summary. So they are just in summary. So I think we'll meet next time. I can see we only have boss lady here and Mito Kapuya. So I can see boss lady is asking my WhatsApp name. We see a name like this one. You see Lubaka Kenyan. That is my WhatsApp name. You see it there. It's my name. So I send you the notes. I'll send you the notes. So I think we'll meet next time, Boss Lady and Mito Kabuya. Hope that is okay. That is okay, Mito Kabuya. Sawa. We'll meet next time.